want to let you know we were here. We had some supporters with us.
Subcommittee will come to order. Welcome to today's hearing on the Adam Walsh Reauthorization Act. I would like to especially welcome our witnesses and thank you for joining us today. I am joined today by my colleague from Virginia, the distinguished ranking member of the subcommittee, Bobby Scobb, also the Chairman Emeritus, John Conyers of Virginia. And I recognize myself for 5 minutes. Today's hearing examines the role of the Adam Walsh Child Protection and Safety Act as a law enforcement tool to apprehend sexual offenders throughout the United States. This act was named for Adam Walsh, a Florida boy who was abducted from a shopping mall and later found murdered. His father channeled his grief into assisting law enforcement with the pursuit and capture of the most dangerous criminals this country faces. As chairman of the House Judiciary Committee in the 109th Congress, I made the adoption of this act a priority. President Bush signed it into law on July 27, 2006. As chairman of the Crime Subcommittee in this Congress, I am committed to reauthorizing this important legislation and seeing that it is fully implemented. A primary component of the Act is the Sex Offender Registration and Notification Act, or SORNA. SORNA establishes a comprehensive national system for the registration and notification of the public of sex offenders. Under SORNA, sex offenders are organized into 3 tiers, with the most serious offenders required to register their whereabouts every 3 months with lifetime registration. SORNA also establishes a national database to incorporate the use of DNA evidence collection and DNA registry and tracking of convicted sex offenders with GPS technology. The law also increased criminal penalties for child exploitation offenses and authorized additional grant money to assist state and local law enforcement with SORNA compliance, to combat child sex abuse, and to assist with fugitive apprehension. The Act also created the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, or SMART. The responsibilities of the SMART Office include providing jurisdictions with guidance regarding the implementation of the Adam Walsh Act and providing technical assistance to the states, territories, Indian tribes, local governments, and to public and private organizations. The SMART Office also tracks important legislative and legal developments relating to sex offenders and administers grant programs relating to the registration, notification, and management of sex offenders. Thanks to the Adam Walsh Act, we have begun to make progress against thousands of sex offenders whose whereabouts are unknown. The U.S. Marshals, who bear the primary responsibility for finding these offenders, have been able to clear over 6,000 cases, with hundreds of offenders eventually convicted of failing to register. I would like to remind the committee members that this act has been challenged in court several times and has been found to be constitutional in every respect. Claims that the law violates due process and claims against retroactivity of the law have been examined in many courts and rejected. This is a fair program, and the goals it seeks to comport with the fundamental notions of liberty and federalism. Yet much more remains to be done. I am not pleased with the rate of compliance with the SORNA provisions. The original compliance date was July 2009, with the ability of jurisdictions to receive two one-year extensions to July of this year. In that time, only 5 states, 2 Indian tribes, and the territory of Guam have been certified to be in compliance with the law. The remaining states and other tribes and territories have had ample time to come into compliance with the Act. In fact, the deadline for compliance for these states has already been extended significantly. I have heard that many states may be close to compliance with the law, and I hope that that is the case as the deadline for compliance fast approaches. As law enforcement officers seek to investigate serial sexual offenders, they are often frustrated to find different states have different ways of categorizing them. The whole purpose of the Act was to make it easier to track these offenders, yet many of the same problems remain because so many states have failed to fully comply with the law. I am eager to hear from the Justice Department why so many jurisdictions have not complied. The Adam Walsh Act is vital to apprehending sex offenders and to protecting our children, and I intend to see that it is fully implemented. And I wish to welcome our witnesses today and thank you for joining us today. It is now my pleasure to recognize for his opening statement the ranking member of the subcommittee, the gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman, and I'm pleased to join you for this subcommittee hearing on the reauthorization of the Adam Walsh Act. It's been over 4.5 years since the passage of the Act, and when it originally passed, I opposed it because it increased mandatory minimum sentences, and it had creation of new federal criminal offenses on top of a myriad of existing and growing state offenses. It criminalized probably innocuous behavior by teenagers, and it created a national sex registry which has not shown value in its stated goal of reducing sexual assault. Since its passage, jurisdictions subject to the requirements under the Act have told us that there are a number of problems and challenges with implementing the Act. In particular, the sex offender notification and registration part of the Act, referred to as SORNA, is proving to be unworkable for the vast majority of these jurisdictions. SORNA requires that individuals convicted of sex offenses register for a period of 15 years to life for conduct ranging from a misdemeanor solicitation offense to felony sexual assault. Even among the few states that have been certified as having met the requirements of these provisions, we're seeing reports of problems and difficult challenges, particularly given the budgetary constraints facing all of the country this time. In short, SORNA is facing a crisis. As of a few days ago, since nearly 5 years after the passage of the Act, I had only 4 states that had qualified, 2 tribes and 1 territory, have been found to be in compliance with SORNA. Remaining 241 jurisdictions face an unjustified and harsh tax on their burn grant funding because if they don't comply, they'll lose some of that funding. As we know, the burn grant monies are used to fund essential state and local programs such as law enforcement and other community programs. It would be a double disaster for states to lose these monies for not being able to afford to implement the requirements due to their current but severe budget shortfalls. Instead, we should consider the feedback that we will hear today and that we've been provided over the past years, and that is to earnestly seek the legitimate concerns that have been raised. Some of the feedback came to us by way of previous hearings in SORNA. In March 2009, when I was chairman of the committee, we convened a hearing on barriers on implementing SORNA. Nearly 2 years later, many of these barriers that we heard at that hearing still exist. These include the high cost associated with implementation, the challenges that requiring juveniles to register pose for the states, including pending legal challenges, and both the legal and practical challenges with SORNA's retroactivity requirement, the whole-scale reclassification of sex offenders, and for Indian tribes, specific challenges, including the loss of sovereignty if the tribes do not comply. At that hearing, we heard testimony from various state and local law enforcement officials addressing each of these challenges. Unfortunately, many of these obstacles still exist. One such obstacle continues to be the requirement that juveniles as young as 14 years of age be placed upon the registry. Despite that this registration requirement is limited to the most serious cases, and that just this year the Attorney General gave jurisdictions discretion to make juveniles non-public, numerous states are still having difficulties with this component due to legal challenges, considerable pressure from advocates and child development experts, and state legislators' discomfort with placing juveniles on a registry. Although continuing to implement another continuing impediment to this implementation is SORNA's failure to allow for an actual risk assessment component to state registries. SORNA does not allow states to use risk assessment tools in developing its registry, which has posed a problem, particularly in those states that had long-standing, effective state registries that used risk assessment tools long before SORNA. These states must completely alter their systems, that is costly, and some have faced a legal challenge in so doing. Research indicates that the risk assessment is an effective way to monitor offenders. We should all prefer a tool that helps determine who is actually at risk of committing another offense, rather than just telling us who committed one in the past. Failing to distinguish between the two between the two defeats the purpose of the registry and makes us actually less safe, not more safe. Now, tribes continue to face unique and compelling difficulties in implementing SORNA. Out of 192 tribes who have opted into SORNA, only 2 have been found to be in compliance. As many of us know, tribes suffer from high poverty rates and struggle with budgetary issues. In addition to losing much-needed burn grant funds, tribes face even a more serious penalty. Shall they fail to implement SORNA, this public function will involuntarily be delegated to the state in which the tribe is located. States will then have to take on the additional responsibility when they're already struggling to implement their own registries without putting them in the difficult position of encroaching upon tribal sovereignty. In light of the double penalty the tribes face, the burden that SORNA imposes on them is onerous. Now, the cost of the barrier of implementing SORNA is a major barrier. For example, California has estimated that the potential cost to implement SORNA will be approximately $37 million. Texas says $14 million will be needed to implement SORNA. These numbers do not only pose a tremendous burden on the states, but also ask us to inquire whether it's worth the money. Are the states going to get a good return on their investment? And while we'll do whatever it takes to protect our children, we must ask ourselves, are sex offender registries effective? The available research tells us that sex offender registries do not actually reduce the number of sexual assaults. This includes a DOJ study.
The gentleman's about a minute over his time. Can he wrap up, please?
This includes the DOJ study funded under Megan's Law, the predecessor of SORNA, well, I'll just insert the rest of the statement in the record.
Okay, without objection, all members' opening statements will be made a part of the record, and also without objection, the chair will be authorized to declare recesses during votes on the House floor. It is now my pleasure to introduce today's witnesses. Dawn Duran is the Deputy Secretary of the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Trafficking Office, or SMART, for the U.S. Department of Justice, Office of Justice Programs. She works to administer the standards of the Sex Offender Registration and Notification Act, including administration of grant programs and providing technical support for SORNA. Prior to joining the SMART office, she served as the Deputy Director of the National District Attorneys Association Child Abuse Program. She was also Assistant District Attorney General in Memphis, serving as co-chair of the Sexual Offenders Registry Violation Unit and a member of the Child Physical and Sexual Abuse Warrant Review Act. She received her Bachelor of Science degree in Public and Business Administration from the University of Tennessee at Martin and her law degree from the University of Tennessee. Ernie Allen is the co-sponsor of the National Center for Missing and Exploited Children and has served as its president and CEO for 22 years. Mr. Allen is also the founder of the International Center for Missing and Exploited Children and serves as its CEO. Under his tenure at NCMEC, more than 150,000 missing children have been recovered. He has received both his bachelor degree and his JD from Louisville University. Stacy Hilton is Director of the United States Marshals Service, having been appointed by President Obama as the 10th Director of the service and sworn in on December 31st, 2010. She has over 30 years of law enforcement and management experience within the Justice Department. Prior to her appointment as Director of the Marshals Service, she served as the Attorney General's Federal Detention Trustee from 2004 to 2010 and was the Incident Commander organizing the Marshals Service response for Ground Zero. She began her career in 1980 as a Deputy U.S. Marshal and has received her Bachelor of Science in Criminal Justice from Northeastern University. Finally, Pat Colleton has served in the Kansas House of Representatives since 2004. She authored legislation on the expansion of DNA testing to facilitate the early detection and arrest of sexual predators, on new approaches to community corrections, and revising laws regarding domestic violence and victim notification. She currently serves as Vice Chair of the Board of Directors of the Justice Center, a national organization under the Council of State Governments which focuses on developing evidence-based practices and laws in the criminal justice system. Prior to her career in politics, Ms. Colleton was a small business owner and attorney who also served as a member of the Johnson County Public Policy Council. She received a Bachelor of Science in Chemistry and Psychology and a Juris Doctorate from the University of Wisconsin, and was in my law school class, so I know she got a very good education there. But before recognizing Ms. Duran, I am informed that the chairman, the most recent chairman emeritus of the committee wishes to make an opening statement, and the chair recognizes the gentleman from Michigan, Mr. Conyers, for 5 minutes.
Thank you very much, earlier Chairman Emeritus of the committee. I'm glad that you were generous enough to allow me to just make a small comment about the hearing today, because I'm not sure about this, but I think with Bobby Scott, I opposed this too a few years back. Only I didn't have the courage to say anything and speak up about it. He went on the floor and gave it was a heroic act, Bobby, ex-Chairman Scott, and I'm proud of you for it. But there are concerns. There are over, I think, 40 some odd states who are in jeopardy of losing part of their burn jag grants in July, and that's going to be a fair amount of money for everybody. The second thing I don't like about this law that we're examining is that it is there's a strict compliance standard that disturbs me a great deal, and I hope that the witnesses will comment on that. I think we need flexibility and compliance. And could someone of our distinguished witnesses, can some talk about the tribal sovereignty issue in this SORNA law that seems to be pretty, it's not being worked in any way that I think is fair to those on reservations. And finally, we have this problem with juveniles. Should juveniles be treated as adults? Not a new problem. And it's so important that it is going to the Supreme Court. We're in the process of examining the registration provision of SORNA may not be retroactively applied to delinquent individuals. The court has said repeatedly, almost, in focusing on juvenile adjudications, that we do not punish our nation's youth as harshly as we do our fellow adults. And so with those qualifications in what we're doing, I find myself in the position of first hoping someday that we'll have a clear examination of this law and make the changes that importantly need to be made. But in the meantime, I don't want to punish the states who are not in compliance. This is an unfunded mandate. Nobody's used that term this morning. And so I will. The states are mostly in a bind. There are very few that are not having incredible funding cuts, And the President's budget release doesn't help things a bit in terms of this and many other areas. And so I look forward to the witnesses, and I yield back the balance of my time and thank the chairman.
I thank the Chairman Emeritus. Ms. Duran, you're recognized for 5 minutes, and everybody's full statement will be placed in the record. So go ahead. Could you push the button on the mic and pull it closer to you?
Is that working?
Yes.
Okay. Good morning, Mr. Chairman, Ranking Member Scott, and members of the subcommittee. I am pleased to have the opportunity on behalf of Director Baldwin, who was called away last night on a family emergency, to discuss the Department of Justice's work to implement the Sex Offender Registration and Notification Act, or SORNA. I am Dawn Duran, Deputy Director of the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, or SMART, within the Department's Office of Justice Programs. The SMART office has the primary responsibility within the Department of assisting states, territories, and tribes in implementing SORNA. The work of the SMART office is a part of the Department's efforts to assist in implementing the Adam Walsh Child Protection and Safety Act of 2006. I am honored to appear today with Director Hilton, our invaluable partner in this effort. I also want to acknowledge another invaluable partner, Ernie Allen, and the National Center for Missing and Exploited Children. We are pleased that Ohio, Florida, Delaware, South Dakota, Guam, the Confederated Tribes of the Umatilla Indian Reservation, and the Confederated Tribes and Bands of the Yakima Nation have substantially implemented SORNA. We are cautiously optimistic that many more states, territories, and tribes will follow suit by the implementation deadline of July 27, 2011. The SMART office provides critical resources and guidance to the 248 SORNA states, territories, and tribes. Since fiscal year 2007, the SORNA jurisdictions have received over $39 million in grants, training, and other resources under our Support for Adam Walsh Act Implementation Grant Program. SORNA addresses gaps in registration programs that are the result of variations in laws, policies, and information sharing, and technology systems across the country. To address some of these gaps, the Act permitted, for the first time, 212 tribal nations to elect to become SORNA registration jurisdictions, and of those, 192 have chosen to do so. The SMART office has provided numerous resources to help these tribes address information sharing and technology gaps. One example is the Tribe and Territory Sex Offender Registry System, or TSORS, available free of charge to all SORNA tribes and territories. TSORS can serve as both the administrative registry system and the public sex offender website system needed for tribes and territories to comply with SORNA. We have developed a similar system to help states called the Sex Offender Registry Tool, or SORT, and another tool called the SORNA Exchange Portal to help all SORNA jurisdictions to share information about sex offenders who are relocating between jurisdictions or are required to register in more than one jurisdiction. These are free of charge as well. The SMART office also administers the Drew Shadeen National Sex Offender Public Website, which is the public's link to information regarding registered sex offenders across the country. All 50 states, the District of Columbia, 3 U.S. territories, and 22 tribal nations have public websites now linked to this site. Many jurisdictions that have not fully implemented SORNA have still made great strides. Director Linda Baldwin has submitted, along with her written testimony, detailed information on SORNA activities as reported by each state, territory, and D.C. The information submitted is based on our frequent contacts with the SORNA jurisdictions. To date, 47 states, the District of Columbia, 5 territories, and 41 tribes have submitted materials to the SMART office for review and technical assistance. The SMART office has reviewed and responded to all but the most recent of these submissions, providing specific guidance back to the jurisdictions regarding their current and proposed registration and notification systems and laws. Despite our best efforts, including the development of supplemental SORNA guidelines that address some of the SORNA jurisdiction's substantive concerns, and despite the efforts of many on the state, local, and tribal level, some serious barriers remain. These barriers include, among others, opposition to SORNA requirements, such as juvenile registration, the impact of government turnover, and the anticipated costs of compliance. Most of the jurisdictions are in the position of having to change their existing laws in order to meet SORNA's requirements. Many states have introduced bills in their legislatures that would move them towards substantial implementation of SORNA. It is difficult to predict, however, which ones will be successful in enacting legislation prior to the July 2011 deadline. The 192 SORNA tribes are facing barriers similar to those of the states, with some variation. Most tribes face challenges in establishing sex offender registration notification systems and codes for the first time. Please be assured that the Department is committed to helping every jurisdiction to meet the implementation deadline, and that we will continue to work to develop the seamless web of public sex offender websites and law enforcement information sharing as envisioned by SORNA. This concludes Ms. Baldwin's introductory statement, Mr. Chairman. Thank you for the opportunity to testify today, and I would be glad to try to answer any questions you or members of the subcommittee may have.
Thank you. The gentlewoman's time has expired. Ms. Hilton.
Thank you, Chairman Sensenbrenner, Ranking Member Conyers, Ranking Member Scott, and all members of the subcommittee for holding this hearing. It is an honor to be here with Deputy Director Duran from the Department's SMART Office, Ernie Allen from NCMEC, and Representative Colleton from the Kansas State Legislature. Thank you for the opportunity to share the Marshal Service's accomplishment and challenges related to this important piece of legislation. The Adam Walsh Act was a monumental bill, changing how this country addresses registering, monitoring, and apprehending sex offenders. This committee, as well as the full House and Senate, showed tremendous leadership in drafting and passing this act 5 years ago. The act added 3 new and important mandates for the Marshal Service: to assist state, local, tribal, and territorial authorities in the location and apprehension of non-compliant sex offenders, to investigate violations of the criminal provisions of the Act, and to identify and locate sex offenders displaced by major disasters. I am proud to say the Marshal Service had made significant strides in each area. To accomplish the enforcement mission under the Act, the Marshal Service took numerous steps, including hiring and training deputies in sex offender investigations, designating leadership positions throughout the agency to coordinate enforcement efforts, creating the National Sex Offender Targeting Center, developing new partnerships with federal, state, local, and tribal agencies to locate and apprehend offenders, and launching specific operations to target non-compliant offenders nationally. Our goal is to leverage our resources and partnerships to maximize non-compliant sex offender apprehensions. For instance, by training leaderships and field officers about our mandates under the Act, coupled with the training of sex offender investigators in our field offices, we have a more knowledgeable workforce at every level. We combine this effort with training for our state and local partners. Approximately 50 agencies have already participated, and we have 2 more training sessions for new participants scheduled this spring. Better training at all levels results in greater number of apprehensions. Last July, the Marshal Service launched Operation Guardian with state and local agencies to target the worst of the worst sex offenders. As this committee knows, the number of non-compliant sex offenders is staggering. The Marshal Service initiated this operation in each judicial district to target the 5 most dangerous sex offenders based on their criminal record, efforts to avoid capture or registration, and danger posed to the public. Let me be clear, every non-compliant sex offender is a potential threat. This operation is working with limited resources with a focus on realizing the greatest success possible. Operation Guardian helps to ensure we find these particularly dangerous offenders and get them off the streets, making our community safer with the resources provided to us. This targeted approach is proving successful, with over half the cases closed in less than a year. The Marshal Service continues to be an agency which prides itself in the extent and quality of its partnerships. Along with the SMART Office, NCMEC, our federal, state, local, and tribal law enforcement partners, we continue to find new and innovative ways to strengthen our relationships. The National Sex Offender Targeting Center at the Marshal Service is a prime example of these partnerships in action. It is an interagency center providing intelligence and resource support to other law enforcement agencies, coordinating international sex offender apprehensions, and generating new behavioral tools for use by investigators. The Targeting Center is an important resource to enforce the Act and to support our partners' efforts to do the same. Our success can be seen in the numbers. Since July 2006, our deputy marshals have initiated almost 8,000 sex offender investigations. In addition, the Marshal Service has either directly arrested or assisted our state and local partners with the captures of over 43,700 sex offenders nationwide. The Marshal Service remains a leader in fugitive apprehension, and the Act provided us the additional assets to make the apprehension of sex offenders to another level. This funding, provided by Congress since fiscal year 2008, directly contributed to this impressive number of non-compliant sex offenders brought to justice. Today, the effective and efficient use of these resources is more important than ever, and these numbers represent a significant return on the investment made by Congress to keep our children and our communities safe. Thank you for the opportunity to testify and for your ongoing support on this important issue. Mr. Chairman, this concludes my remarks, and I am pleased to answer any questions.
Thank you, Mr. Allen.
Mr. Chairman, Mr. Scott, Mr. Conyers, the National Center for Missing and Exploited Children was a fervent supporter of the Adam Walsh Act in 2006. We remain so today. As of our latest state survey in December, there are now 728,435 offenders in the United States required to register and update their information as it changes. As many as 100,000 of those offenders are missing or non-compliant. The number of registered offenders is going to continue to grow, and clearly states are struggling with the challenge. Yet we believe that states benefit from strong federal cooperation and leadership under the Adam Walsh Act. For example, as you've heard from Director Hilton, the U.S. Marshal Service is tracking down serious fugitive sex offenders. We're grateful for the dedication and commitment of the SMART Office and their support of the states and tribes as they move toward compliance. Congress also mandates that the National Center provide training and technical assistance to law enforcement in identifying and locating non-compliant sex offenders. And we're doing that. In 2006, we created a sex offender tracking team, which receives daily requests from states and localities regarding missing sex offenders. Our analysts run searches using public records databases donated by private companies. We're looking for links between non-compliant offenders and child abductions, attempted abductions, and sexual exploitation cases. We then forward that information to the appropriate law enforcement agency in a leads package, which is then used to search for fugitive offenders. To date, we've provided more than 6,000 of those leads packages, with more than 1,200 fugitive sex offenders located and arrested as a result. And at the request of the Marshal Service, we are assigning 6 of our analysts to their sex offender targeting center to assist in their efforts. Regarding SORNA implementation, we believe that we have begun to see real progress. It has been a challenge, dependent upon both the executive and legislative branches of the states to act. These efforts were delayed because the guidelines on SORNA implementation were not issued until 2 years after the law was enacted, providing no clear direction until 2008. We are pleased that efforts are underway today in most jurisdictions to work toward compliance. According to our friends at the National Conference of State Legislatures, 41 states enacted SORNA-related legislation in 2009. 28 states enacted SORNA-related legislation in 2010, and 23 non-compliant states are currently working on legislation that will bring them closer to achieving substantial compliance with SORNA. And Mr. Conyers, that's the language of the statute, not strict compliance, but substantial compliance. And we think the SMART Office is working in good faith with these states to achieve accommodations where appropriate under the law. We recognize that states have faced barriers. A 2009 survey responded to by 47 states indicated 4 primary obstacles. 23 states cited the juvenile registration and reporting requirements. 20 states cited the retroactive application provisions. 7 states cited the tier-based system, and 7 states cited cost. In January, Attorney General Holder published supplemental guidelines that, in our judgment, effectively address and resolve the concerns of most states about juvenile registration and the retroactivity provisions. We believe that the Attorney General's guidelines pave the way for many more jurisdictions to come into compliance with SORNA. Congress has appropriated funds for grants to states to help with compliance efforts and to fund the marshals for their Adam Walsh Act responsibilities. We hope that Congress will remain committed to funding these efforts. Mr. Chairman, we share your frustration that just 7 jurisdictions have become compliant in the 5 years after the passage of the Adam Walsh Act. However, we believe that today the primary obstacles have been overcome and that many more jurisdictions are moving toward compliance. We believe that the goal of building a better, more unified sex offender registration system across the nation is within reach. Thank you.
Thank you. Representative Colleton.
Thank you, Mr. Chairman. Chairman Sensenbrenner, Ranking Member Scott, and members of the subcommittee, thank you for the invitation to testify today about the Adam Walsh Act and efforts by states to implement the Sex Offender Registration and Notification Act, SORNA. As chair of the Corrections and Juvenile Justice Committee in the Kansas House, I have focused my time in the legislature on protecting those who are vulnerable and holding offenders accountable for their crimes. I believe Kansas is one state that, like many others, is working diligently to walk the line between implementing the policies established by Walsh and policies developed within Kansas over many years that address our specific needs. Kansas has a long-standing commitment to the safety of our citizens, of course, and then particularly to our children. 17 years ago, Kansas passed its Sex Offender Registration Act, which created a statewide registry for specified sexual offenders available for law enforcement use. As of last year, over 5,000 sex offenders are in the Kansas registry. We include all sexually violent crimes and all crimes involving children under 18 years of age in our registry. We have passed Jessica's Law, a mandatory hard 25 years for sex offenders, and we made failure to register for 30 consecutive days a prison-level felony. These policies reflect Kansas is serious about registration compliance. We have also learned that keeping Kansas safe from the threat posed by known sexual offenders requires more than a good registry. It requires an entire coordinated system of assessment, management, and supervision that starts from the day the offender walks into the courtroom and extends through their ultimate release into the community. Kansas has legislation ready to proceed that would bring us more into line with the standards set forth in Walsh. We have every intention of complying with Adam Walsh by enabling our registry to link to the nationwide SORNA database. Even with our sincere commitment to comply with the Herculean efforts that we have taken, bringing our state into compliance is a time-consuming and sensitive process. We have set up a state working group to assist us with determining the scope of our implementation package. We set up that state working group in 2006 and then waited for the very first regulations to come out in 2008. What we cannot guarantee is that the changes that we have put into the legislation, the bill before my committee to be heard later this week, will be adopted wholesale or without change, despite the threat of losing that burn jag money. So we need to applaud the SMART office. They have worked extremely hard with Kansas and other states. They've been courteous and professional. They've gone through many different issues with us, and we've got a package that we've worked with them. We just don't know if we can whip it through the legislature this session. While only 7 jurisdictions have been classified as compliant with Walsh, there has been significant work done and progress that should not be overlooked. Over 250 pieces of legislation have been passed across the country since 2006. What you implemented with Walsh, Mr. Chairman, and those of you who supported it, was a whole bevy of pieces of legislation that enact pieces of the Walsh compliance picture. Why the delay? There are several issues. First is timing. Congress intended to give jurisdictions 5 years to come into compliance, but the implementing guidelines didn't come out for 2 years, 2008, leaving these jurisdictions only the 3 years to demonstrate substantial compliance. Additionally, in January of this year, Significant SORNA implementation issues were finally clarified in the final supplemental guidelines released by the Attorney General. Now, those guidelines are very helpful, and I agree with what Mr. Allen just said. They make compliance very, very possible, but they came out in January of this year. States simply need more time. Even a state like Kansas that has a written and introduced a bill needs more time to address the SORNA requirements in full. Secondly, the second issue that we have concern is that juvenile registration. A number of states in compliance with other requirements of SORNA are hesitant to adopt the juvenile offender notification requirements. Many lawmakers from across the country on both sides of the aisle oppose lifetime registration and public notification for juveniles, especially because juveniles that exhibit proven sexual behavior are less likely to reoffend and more likely to benefit from treatment and intervention. In summary, is that a hint? Aha. Okay.
Yes.
In summary, the costs are great, but the benefits of that national portal are excellent. We are working hard to comply, but given the whole process, we need more time. We consider the Adam Walsh a benefit to us, and we're working to get there.
Thank you very much, Representative Colleton. The chair will now recognize members for 5 minutes apiece, alternating by sides in the approximate order in which the members appeared for the hearing, starting with me. Representative Colleton, if you can't make this deadline, how much more time do you think Kansas will need to come into substantial compliance?
I would give us 2 more years in the sense that it may well be that we start to vet the policy changes contained in the agreement we've reached with the SMART office, and that we are unable to pass it this legislative session. Remember, we're a 90-day citizen legislature. We do meet every year, thankfully. Some of the states only meet every other year. So I would say, if you would give us next session, we may well do it. If you're including all states, I would say you need a 2-year time frame for those tentative agreements, particularly under the January guidelines, to come into fruition and be passed in legislation.
Do you support the carrot and stick approach where the stick is reducing burn JAG funding?
Not fully, in this sense that much of that money is used for victim treatment, for community corrections treatment of sex offenders when they re-enter into the community. To take that kind of money away when it's the very money that helps us control, track, and monitor, to do what's smart, monitor and track, I think is counterproductive. But what I would see as kind of being fair about it might be where you give some credit for those states that have done at least a partial compliance with SORNA. You know, every state I think, has pretty much done some of the pieces of SORNA. I mean, you've unleashed here with the Adam Walsh Act a whole variety of advances in tracking, apprehending, and then monitoring sex offenders. So we're well on our way. I think we are. And I would give partial credit, perhaps, or determined by the SMART office, and maybe take a little away. For example, you're thinking 10% of burn JAG money. Maybe you would give 90%, 80%, 50% credit and not take it all away. It goes for very good causes related to sex offense.
Thank you very much, Mr. Allen. What is your view on how states are complying and your response to the additional 2-year proposal that Representative Colleton has put on the table?
Mr. Chairman, I think Representative Colleton makes a very good point, and we too have been concerned with the total loss of burn JAG funds for states that have really made a substantial effort and have not quite gotten there. So some proportionate allocation of that, we agree, makes sense. Our primary concern about extension is that our sense is that states have really worked diligently. Many states have worked diligently to come into compliance by July of 2011. Our concern with an extension is that I fear if the extension is provided, states will just delay further in their process, which I don't think is unheard of in these kinds of processes for a variety of issues. So I think there's a real balancing act here. I certainly agree with Representative Colleton's point about the fact that effectively states have only had 3 years to come into compliance. And I think she makes the point, and certainly the data we have from the leading associations indicates that most states have really made diligent efforts, including passing various pieces of the legislation to try to get to compliance. So I think that's not to pass the buck, but I think that's something Congress needs to weigh, and that is an extension may effectively reduce the total number of states that are compliant as of July of this year.
Well, I believe in deadlines, and excuses are going to have to be valid if there is to be an extension considered. And this will, I'll look at all 50 states and a good percentage of the tribes to make a determination on that. I really don't think 2 years is appropriate, because I have a feeling that people won't get worried about this until January of 2013. And
exactly
governors do like to call special sessions of legislatures upon occasion. My time is up. Gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, we've just heard comments about losing all of the burn grants. Mr. Rand, if a state is out of compliance under present law with no extensions, how much of the burn grant would they lose?
If a state has not complied by July 26 of 2011 and has been determined that they have not substantially implemented, the penalty is 10% of their burn JAG funding. However, of course, the Act provides for a reallocation. If a state is continuing to work towards substantial implementation of SORNA, they may apply for that 10% back to their state to work specifically targeted towards SORNA implementation activities.
Thank you. Ms. Hilton, Mr. Allen indicated that there are approximately 100,000 people who are on the registry that are out of compliance. What do you do with that information?
Sir, we continue to work diligently across our partnership relationships with the SMART Office, with NCMEC, and our state and local and federal law enforcement partners to continue to apprehend. Again, I think that, we stand in a great position with the Marshal Service to say, of those that were non-compliant, we've actually, with our state and local partners, either had a direct impact or assisted with the apprehension of over 43,000 sex offenders nationwide. So we continue to work those numbers, and I think
you have apprehended and incarcerated 43,000?
we have assisted or had a direct apprehension of over 43,000 since the Act was passed in 2006.
Okay, Ms. Duran, has the Department of Justice done studies to show the recidivism rate for those states with a registry and those who do not have a registry?
Are you referring to under SORNA?
Right. Does the registry reduce, does the fact that somebody has to register reduce recidivism?
I'm not aware of any studies that have been conducted yet on SORNA and its effects or its goals.
What about
or
Megan's
objectives.
Law?
Under Megan's Law, there have been some studies produced under that.
And what did they find?
The main purpose of registration and notification is, of course, registration for law enforcement purposes and sharing of information and providing
does the fact that
information to
there's
the
a
public.
registry reduce recidivism?
I would have to get back to you on those studies.
Are there any studies that show whether or not someone who is compliant on a registry versus someone who is not compliant on a registry is more or less likely to offend? In other words, the list of 100,000 that Ms. Hilton is chasing down and incarcerated, is that list more likely to offend than those on the registry that are in compliance?
No,
No, there's no difference.
that's correct. They're not shown to be more or less likely.
The fact that you're not in compliance does not mean that you're any more likely to offend than if you're out of compliance. That's the finding of the studies.
That's one study, yes, sir.
What is the, Ms. Colleton, the juvenile issue, why are states reluctant to have juveniles register on these public registries?
Well, there's a couple different reasons, and one is that juveniles that exhibit problem sexual behavior are much less likely to reoffend, and their brains are developing. They're much more susceptible to treatment. And so I think to treat them and put them on a public registry and put them on registration creates issues for them that are exactly the opposite of the paternalistic juvenile system that we've created in juvenile justice. And I think it's counterproductive. There's one other thing I would like.
Well, when you say counterproductive, are you suggesting that putting a juvenile on the list would alter their future opportunities such that you're actually increasing the likelihood that they'll get in trouble in the future?
Yes, absolutely. I think that if that registry is published, and just as of January now, it doesn't have to be published, and that means states will have 6 months if they believe in that policy to comply. I believe in deadlines too, but we've got 6 months from the final regulations now till July when the penalties start to go into effect. 6 months, and there's still some issues like the juvenile where there really hasn't been a resolution. The other area that there hasn't been a resolution on that I'd like to speak to for just a second is risk assessment. It's very important to know that many states who've had registries for a long time do their tiering based on risk assessment, because just because you've pled down to a low felony doesn't mean that you're a lesser sex offender risk. And we should allow, the one other thing that's really needed here under Adam Walsh in supplemental regulations, and then we would need some time after that to get it done, would be that we allow risk assessment to be used in states as the different tiering. New Jersey did the very first Sex Offender Act in 1992. They did Megan's Law, the first registry, and they have done tiering based on risk assessment since then. Adam Walsh is requiring them to change that process and not use risk assessment. That's one other thing that is very much needed, and it's critical with regard to juveniles.
Mr. Chairman.
Gentleman's time has expired. The
Mr.
gentleman
Chairman,
from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Ms. Doran, who's responsible for the 2-year lag in promulgating guidelines?
The SMART office was stood up in 2007. The act was passed in July of 2006, and the SMART office was stood up at the beginning of 2007. And I wasn't there for the
The
beginning.
SMART office is part of the Department of Justice?
Correct.
But the Department of Justice was around in 2006,
Correct.
right?
Correct.
So who's responsible for the 2-year lag
The
in
guidelines,
promulgating guidelines?
the guidelines first have to be issued as proposed guidelines, and they went through a lengthy and extensive commenting session for that before, and then all of those comments from the proposed guidelines were then accumulated and reviewed, and based on those, they adjusted the final guidelines, which were issued in
Do
2008.
you think 2 years is a reasonable length of time to take to promulgate guidelines?
The initial guidelines were quite lengthy and complex because, of course, the Adam Walsh Act is quite lengthy and complex. And so I know that the Department of Justice took their time to make sure that they provided all of the information that they could provide.
Let me
to the states
rephrase
and
the
tribes.
question. Do you think 2 years is a reasonable amount of time to promulgate guidelines?
I wouldn't have a position on that one way or the other.
All right. Ms. Colleton, Representative Colleton, excuse me. I've been listening this morning, and it seems as if there are only 2 alternatives with respect to juvenile registration. Either we're going to have a public list or we're going to have a law enforcement only list.
Correct.
There are other alternatives, correct? I mean, you can have a list where camps could, I mean, you acknowledge that it's not just law enforcement that would want this information.
Oh, absolutely. And I know within Kansas, and when I mentioned those 250 changes in law and that kind of thing, one of the things that's happened is, of course, these registries are being made available to different agencies that deal with children, as you say, some private organizations that deal with children and all of that. So, yes, there are steps between complete. Kansas had the very first, in 1994, publicly open sex offender registry. We also, by the way, had the very first in 1997 website registry, but we didn't do it for juveniles. For juveniles, we limited it to some agencies, some very well-known, well-regarded private institutions that dealt with children.
14-year-olds can be prosecuted as adults for homicide and in some instances incarcerated for up to half a century. So there's no Eighth Amendment issue with respect to public registration. You agree?
Yes.
All right, so in the course of a minute, you and I have agreed the alternatives are public registration, law enforcement only, or registration where interested groups can ask whether or not this person, this putative employee or hiree, is on a list. You and I did it in a minute.
That's right. And
Why do we need 3 years?
why?
Why 3 more years for implementation? You and
Well,
I did it in a minute.
I was suggesting too, I think with the tribes, because they don't have the kind of digitized requirements of Adam Walsh, you probably need more than that.
Why do we
But
need
with
2?
regard to states, we need 2. And simply for this reason, the final supplemental regs came out in January. What they did, they changed several things.
Let me stop you right there. Who's responsible for waiting until January to put out the final regs,
Well, they came out of the SMART office.
which is part of the Department of Justice?
Yes,
And this law was passed when?
2006.
And we waited 2 years for regulations, and then we waited until January of which year for?
This year, 2011. And what I'm saying is, the SMART office has been excellent to work with. All last year, they worked with a group very hard, and the year before as well. We have a working group to comply with SORNA. It was set up in 2006. It has on it prosecutors, judges, law enforcement.
You will acknowledge the difficulty in convincing people that 5 years is not enough time.
We agree 5 years, but it's got to be 5 years from when we know what we're supposed to do.
What's a better motive for compliance than federal funding?
Oh, how about protecting our children? I mean, we absolutely believe that this is an excellent, the national portal that SORNA sets up.
When you say protecting our children, are you suggesting, are we going back to the juvenile registration argument?
No, what I'm saying is,
Because
our
when you say
state
protecting
and
our
others
children,
are-
that argument can go both ways. I can also ask you why it's taken 5 years.
you can also ask me, I'm sorry.
My time is up, Mr. Chairman.
Gentleman from Michigan, Mr. Conyers, is recognized for 5 minutes.
Let's look at the tribe problem with the Indians. I know you're here representing someone that couldn't be here, but none of you have even mentioned the 212 Indian tribes. Is it because you don't know about them or you don't care about them?
The tribes actually have built into the act a reasonable amount of time after the deadline for them to be able to implement. So they already have some extra time, and the Department of Justice is very committed to working with the tribes to continue to assist them with their implementation efforts.
Boy, is that standard bureaucratic retort. Look, you must know, I found out in 5 minutes that the tribes don't get out of anything. The states will reimpose their activity, isn't that right, Mr. Allen, on the tribes. So they're not getting away with a thing. That's the excuse that you folks come here to the committee and make us feel that the tribes are okay. The tribes are going to get it in the neck. And if you don't know it, then I'm glad we're holding this hearing. What do you say, Mr. Allen?
Mr. Conyers, I think the reality is that tribal law has different challenges. The whole issue of tribal sovereignty. There were provisions written into the statute. We've met with the National Congress of American Indians on these issues. Clearly, the SMART office has dedicated personnel to follow up with the tribes and try to address these legal issues, but there's no question they're going to take more time. And there's also no question that state compliance may effectively roll in some of these tribal governments under that. So I think the SMART office has been trying to respond, but there's not a lot of clarity in the initial statute on tribal governance issues.
Well, the National Congress of American Indians are asking for 5 more years. Do you know that?
Yes, sir.
Well, why don't you say so?
I do. As I said, the act itself builds in a reasonable amount of time, and I think
But they're asking for it. That doesn't mean they get it.
correct, but the act itself builds in an extension of time for them. And as I said, the Department of Justice is not going to delegate their responsibilities to the state. The Department of Justice is committed to each and every tribe that's wishing to implement SORNA, to work with them past the deadline to continue their implementation efforts.
All right. Now, do you know that the states take over when the tribes can't meet these deadlines?
I'm sorry, can you repeat the question?
Do you know that the states take over when they don't meet these deadlines?
If a tribe is eventually delegated over to a state for registration and notification, but that's our absolute last resort. The department doesn't intend to delegate any tribe that has any intention and wishes to work towards implementation. And most tribes are doing so.
Most tribes are doing so. There are only 2 that are in compliance out of 212.
That's correct. Quite a few tribes are
Well, why are you saying that?
Quite a few tribes are working towards implemenation, just like
Well,
the
look,
states are.
everybody's working toward it.
They're submitting
All
materials.
the states are trying. Please.
That also, over half of the
give me a
tribes
break,
are already
will you,
in
this
either
morning?
the testing stage or in the actual stage of connecting to the Tribal and Territory Sex Offender Registry System and the National Sex Offender Public website, which is half of
Look,
their
thank you
requirements.
very much. Mr. Allen, can you show some sympathy for the juvenile problem? It's going to the Supreme Court, and Attorney Nicole Pittman, who we wanted as a witness, but we only have a rule of 4, it looks like there's a constitutional problem as big as this room involved in that Supreme Court case coming up. Could you show us a little sympathy, even just for the hearing?
Well, no, Mr. Chairman, I think there has been that kind of sensitivity, and I think it's reflected in Attorney General Holder's supplemental guidelines. What the provision?
Oh, here we go again.
No. I mean,
well, you know, he made some changes. I'm glad he made some changes.
The time of the
That
gentleman
doesn't
has
even begin to deal
expired.
with it.
The gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. Ms. Duran, following up on the gentleman from Michigan's question, how many states and tribes do you expect to comply with this act by the July 2011 deadline?
By the July 2011 deadline, we are very reasonably comfortable that between 10 and 15 additional states will be able to implement by July. In other words, they don't have any large substantive barriers or challenges, and they feel comfortable that their legislatures are going to be able to pass this.
And that's in addition to how many are in compliance
In
now?
addition to the 4 states and the 2 territories and the tribes. We think we do believe that an additional between 25 and 30 states may or may not be able to meet the deadline. It's really too soon
And how about
to
the
tell.
tribes?
These are all in session. The tribes are definitely not going to be in the same position. We have reviewed materials for about 50 tribes at this point, and as I said, as I was telling Chairman Conyers, that they are all connecting to the sex offender registry system, but they are going to need more time. The department is committed to doing that under the reasonable amount of time extension under the Act.
Okay, and in the last 3 years, your office has awarded over $25 million in implementation and planning grants. How's this money been used by the jurisdictions? And first of all, how has it been distributed? Are all 50 states and 212 tribes availing themselves of this money, or?
It's a discretionary grant program for the Adam Walsh implementation, support for Adam Walsh implementation grant program. It's been a discretionary program since 2007. Every eligible jurisdiction, all 248, are eligible to apply.
How many have?
To date, I have the information here and has been submitted. To date, I would say we have total, I would have to get you back the exact number, but what I can tell you is, as of last year, we were able to fund every jurisdiction that applied last year.
But you don't know how many applied?
Last year we had 28 jurisdictions.
Is that, and is over 3 years, do you know how many?
I cannot give you an exact number right now, but I can get that back to you.
Let's say we're 3 times that number, around 75. Is that an indication that there are 175 jurisdictions that think so little of complying with this law that they're not applying for the funding, but they're still complaining about not being able to comply? What's the...
No, not necessarily. Out of the 7 jurisdictions that have implemented, 4 of those didn't receive any federal funding.
Okay.
So,
Very good. And your office has also provided software platforms for the states and tribes to use to build their capacity to feed information into the National Sex Offender Registry. What has been the impact of that software?
the software has been an enormous success, particularly for the tribes. I know I've talked about it a couple of times, but the Tribe and Territory Sex Offender Registry system has been enormous for the tribes. Over half of them are now in the testing stage or using it. And out of this great success from that, the states asked if they could also have a similar tool developed for them. And we've developed the Sex Offender Registry tool. And quite a few states, as many as 10 right now, are testing it or looking into it and are using that tool as well for their registry system.
Thank you. Ms. Hilton, are there any additional law enforcement authorities that would help the Marshals Service to better investigate and track sex offenders?
Yes, there is, and thank you for that question. The Marshal Service would greatly benefit from documentary administrative subpoena authority. You know, as you can appreciate in any investigation, but one of so sensitive in protecting our children, the ability to immediately react during an investigation is critical to the apprehension of the fugitive or the non-compliant sex offender. And so having the ability to have documentary administrative subpoena would allow the investigators real-time information that's critical to apprehending the individual. That would be the greatest asset we could receive at this point to take our Adam Walsh Act responsibilities to a higher level.
Let me get one more question for my timer. Are there other agencies that have the ability to issue administrative subpoenas, and have they been used without overreach on their part? Do they have a good track record?
Thank you. I appreciate that. Yes, I believe that there are within the Department of Justice, DEA, FBI, have the ability. It has proven effective. I cannot speak at this point to the integrity of their processes, but certainly, if given that ability, what we're really looking for is documentary, which is an asset that would provide us limited responsibility, but allow us to get what we need on the fugitive investigation. So it would serve vital to us. And we would look at the best practices when we implement that, and I'm confident that we can keep the integrity of the authority intact.
Thank you, Mr. Chairman.
Thank you.
Time of the gentleman has expired. The gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman, for holding this very important hearing, one that affects the lives of many people, many of them who don't belong on a child sex registry or any sexual registry. And what we have here today is an act. For some reason, it's called the Adam Walsh Act. I don't know if there's ever been any evidence uncovered that would establish the fact that this horrific murder of Adam Walsh had anything to do with a sex act. But nevertheless, that's the name of the act that we are dealing with here today. And that act is pretty strict and pretty broad in scope. It requires that all persons convicted of a sex offense must be placed on sex offender registry. That's correct. Is that true?
Above a threshold.
Above.
There's a threshold of severity that requires you have to. So very minor offenses would not get you on a sex offender.
Well, certainly a definition of what constitutes a sex offender act is any criminal offense that has an element involving a sexual act or sexual contact with another. So that means, does it not, that just simple possession of child pornography would require the placement
automatically of a defendant or a convicted person on the sex offender registry. Isn't that correct?
That's not correct. If
You don't
it
think
is
so?
a Tier 1, they have to register
Okay,
for the law enforcement database, the National
Um,
Sex Offender Registry.
The
Okay.
chair
Wait a
would
minute.
remind members of the audience that they are here as guests of the subcommittee, and expressions of support or opposition to any of the statements are specifically prohibited by House rules.
And if I might get back my 20 seconds.
You may.
Okay, thank you.
Tier 1s do not necessarily have to be publicly posted. It is
Okay,
up
well,
to
now
your
that's
discretion.
fine. That may be true in some states.
Correct.
In other states, it may not be true. But it's also true that just a online chat with someone, between persons talking about sex, and one person to the conversation is actually a child posing as an adult. That can be an offense that renders one subject to placement on that sex offender registry. Even sex between, say, a 17-year-old and a 15-year-old, consensual, requires placement on the sex offender registry. Now, I see you shaking your head, but I'll tell you, being a criminal defense lawyer for 27 years before I became a congressman, I handled many cases involving allegations of misconduct involving sex. And so I know what I'm talking about in Georgia. Even when you're placed on this sex offender registry, you cannot live within, say, 500 feet of a child, or of a school, or of a playground, or of your neighbor's backyard pool where there are children who may congregate. And so therefore you have to establish a place somewhere 500 miles from nowhere where there are no children as the only place for some people to live. Now, I want you to answer this question for me. Is there anybody here who has any objection to, instead of applying rigid sets of federal law to an offense, compelling placement
Gentleman's
onto
time
a
has expired.
registry, that you would not support an
The
amendment
gentleman's time
that would
has
enable
expired.
a judge, based on the facts and evidence
The
before
gentleman
them,
will suspend.
To
His
make that-
time has expired, including the extra 20 seconds. The gentleman from Pennsylvania, Mr. Marino.
Could they answer the question, sir?
The gentleman used up all of his time. The gentleman from Pennsylvania, Mr. Marino.
Mr. Chair, I yield my time at this.
Okay, the gentleman from Texas, Mr. Poe.
Thank you, Mr. Chairman. Thank you for being here. Back in 2005, I was one of the several that helped write the Adam Walsh Child Safety Act. I think it's a good piece of legislation. At that time, we were concerned about some of the horrific crimes that were being committed in the United States. For some reason, in that year and subsequent years, there was almost an epidemic of young children being kidnapped by sex offenders, previous sex offenders, and taken throughout the United States, and criminals committed or continued their criminal ways. I want to thank Ed Smart for being here today, and my good friend Mark Lunsford as well. Mark, like you, I have a photograph of your daughter in my office, and I will continue to do so for as long as I'm in Congress. Because of the crimes committed against the Smart family and Jesse Lunsford, we saw a need to try to keep up with these child molesters when they commit a crime in one state. They may register in that state, and then they flee to another state to continue their criminal ways. That was the purpose of the Adam Walsh Child Safety Act. If it needs to be tweaked to refine it more, let's tweak it. But let's make sure that the law is enforced. A person who is a registered sex offender, according to our court system, does not have a constitutional right to be anonymous anymore. I agree with that provision. There's no one that values privacy more than me, but in this case, a person, once they choose to commit a crime against America's most innocent, we need to know who they are, and we need to have them on a registry. If we need to fix it for juveniles, that's a different issue. I'm going to address some questions to Ms. Hilton and then to you, Ernie Allen, in the remaining time. Ms. Hilton, do you think that the law, the Adam Walsh Child Safety Act, is a necessary tool to protect children, our society, the Adam Walsh Child Safety Act?
Yes, sir.
Why?
It allows us the opportunity to, within the federal system, to provide our assets and our ability to reach further across the nation in the apprehension of non-compliant offenders and also violent offenders. So, as you know, at the state and local level, they don't always have those resources. By integrating the U.S. Marshal Service into the process through the Adam Walsh Act, it allows them to provide their information to us and us to provide our assets and our knowledge and our tracking abilities to quickly apprehend these individuals and protect our children. There's no doubt about it.
Mr. Allen, thanks for your work in missing and exploited children. It's a noble cause to take care of America's kids. What do you think about the Adam Walsh Child Safety Act and what Congress should be involved in or not involved in this area?
Judge Poe, we think it's incredibly important. The reality is 6 years ago, 5 years ago, and today, we still face a wide range of disparity from state to state in terms of existing law. And there is no question but that the most serious offenders take advantage of those gaps. The goal of the Adam Walsh Act was to create a system where there is far greater consistency from state to state and to provide a reasonable federal role. We think the Marshal Service is doing that. If you heard Director Hilton's numbers, we're identifying these traveling offenders and bringing them to justice. I recognize Representative Colleton made a good point that there are states that have been out there doing important work in this space. The oldest sex offender registry in this country is California's, which was created in 1947. This is not new law. This is not a new concept. The goal is simply to eliminate the gaps. One of the reasons we still estimate the number of non-compliant offenders is that many states, maybe most states, still don't know how many of their registered sex offenders are non-compliant. Because what we saw was a situation in which offenders were registering by mail without that kind of personal presence. So we absolutely believe in the law. We think clearly that there has been a process to reach a reasonable level. We think the Attorney General's guidelines on the juvenile provision, which eliminate convicted juveniles being on the public registries and websites, we think it's a reasonable step forward, but it doesn't mean that there aren't serious offenses being committed by juvenile sex offenders who are starting when they're very young.
Thank you, Mr. Chairman. I yield back.
Thank you. A gentlewoman from California, Ms. Chu.
Thank you, Mr. Chair. I address this question to Mr. Ann and then to Mr. Allen. I do come from California, which was indeed the first state to establish the sex offender registry back in 1947. Since then, we've made great advances, and we have established the California Sex Offender Management Board, which came from a bill that I wrote when I was in the state legislature. What it does is bring together law enforcement, judicial officers, probation officers, treatment professionals, and advocates together to fashion a comprehensive way of dealing with sex offenders and actually reducing recidivism on a more comprehensive basis. And these are on a variety of variables. There basically is a risk assessment that is done for these variables that have high correlation to sexual recidivism, such as criminal history, victim profile, and age at the time of offense to determine an offender's risk of recidivism. But the Adam Walsh Act bases the offender's crime only on conviction and not on any kind of risk assessment score. So I believe that we have a superior registration system in place, and I want to know what are the state's rights in a situation like this. We don't want to replace our superior system with the Adam Walsh system. We have put a lot of time and a lot of expertise into a system that will actually reduce recidivism. So, Mr. N.
Thank you for your question. California's system, as with most of the states that use risk assessment, is not inconsistent with SORNA's purposes. Yes, SORNA does require a conviction-based offense for their initial registration and tiering, but risk assessment can be used and is not incompatible with SORNA for purposes of public notification, treatment, supervision, and the other uses that people and states use risk assessment for. We did issue, there has been a lot of confusion about that among the states, and we did issue a clarification document entitled an implementation document on the uses of risk assessment consistent with SORNA. And we are in contact with California and hope that we can move forward on some of those issues, as well as their information sharing that they're working on.
Well, I'd like to follow up on that because the California Sex Offender Management Board has recommended that California not come into compliance with the Adam Walsh Act. And the reason is not only what I've just mentioned, we believe we have a superior system, but also the monetary situation is utterly ridiculous. The cost for implementation of the Adam Walsh Act would be $21 million to probation for conducting pre-sentencing record checks, $10 million for local law enforcement agencies to conform with changes in frequency of registration requirements, $770,000 one-time cost to Attorney General's office to re-tier the registered offenders. This amounts to $32 million, and that doesn't even calculate the cost of an additional incarceration. But the amount that we would get from the JAG burn funds is $2 million. So $32 million we would lose, $2 million we would gain. What is the point to this?
Well, I would also add that the responsibility to implement is an ongoing responsibility every year. So unfortunately, that penalty will be applied each and every year that California or any other state doesn't come into compliance with the Adam Walsh Act. And I am glad that you brought up the cost. There has been a lot of information given on costs as well. If you would like me to expand a little bit on what the SMART office has been able to learn so far about true costs of implementation.
Well, you're saying that California would comply and that there are some state rights. You're saying that there was confusion and that now they would qualify. But are you saying then that they would qualify for these JAG burn funds?
If they were to substantially implement, California would need to work with the SMART office and submit their legislation and their substantial implementation packet to move forward. And we're happy to do that with California. We've actually made more in-person visits to California than any other state, attempting to work with them on implementation of SORNA, and we look forward to continuing to do that with California.
Okay. Mr. Allen, do you have any comment on this?
I think the only point, Congresswoman, that I would raise is that, as I understood the debate at the time of the Adam Walsh Act, a number of states were doing some variation of risk assessment, but they were all over the place. And my understanding is that bipartisan leaders of the Congress concluded that the Adam Walsh Act was intended as a floor, as a minimum set of steps that states needed to take. And the reality is that I think it was felt that the best predictor of future behavior is past behavior. So I think that's why that was used. But as Mr. Rand points out, it does not preclude states from applying and using risk assessment tools as long as they're substantial and meaningful.
Gentlewoman's time has expired. Gentlewoman from Florida, Ms. Adams.
Thank you, Mr. Chair. Ms. Dorn, I have some questions, but you wanted to expound on the cost, and I'm curious about that.
Sure, absolutely. The cost of SORNA really for the jurisdictions can be divided into two major categories. One is their startup costs that they will be required to do, mainly their information technology infrastructure and reclassification, any costs that are associated with that. And then they have their ongoing or their maintenance costs that are associated with implementation of SORNA, which is mostly in the category of personnel, because for many jurisdictions, depending on their reclassification, they will need additional personnel, additional equipment to handle additional check-ins and probation and supervision. But what we've learned so far, we've gotten actual numbers from one state that has implemented, and Ohio's number for startup costs for implementation was a little over $400,000. And now that doesn't include their ongoing maintenance costs, and Ohio is keeping us informed about that as they move forward.
Thank you. And I've heard a lot about the risk assessment tool and how it's used. Are there any, how long have they been using these risk assessment tools? I know California's had one for a while, but how are they tested? What's the research on it? Can anyone answer that?
I mean, go ahead, I'm sorry.
Sure. The LSIR, the level of service risk assessment, is used by most states to guide who is a high risk at recidivating and then who isn't, and to guide how much time you're going to put in monitoring them, what sort of treatment and that kind of thing. And it looks at 20 different factors. It's a test, and it's a dynamic test, because it goes to things like what are their leisure activities, what sort of mental health background have they had, what are the substance abuse, et cetera. It combines that. And what's so misleading and a problem when we're making these changes for the Adam Walsh Act is that that's how we manage offenders. We manage them based on dynamic risk factors, and we have very limited resources, so we use those to determine how much of a parole officer staff we put on it, all the rest. But now, what we will put on the public registry will just be the plea bargain that they got, the offense that they got convicted of, so that somebody with a low-level sex offense may be a very high risk, may be a real danger to our children. And what Adam Walsh requires, and where we need to change that still, and give us a little more time then, is allow those states who wish to have their public notification relate to the risk, the same risk that we supervise on, rather than just the name of the crime, the level of the crime that they happen to be convicted of in the plea bargain. So we are absolutely on the same page with Adam Walsh on the public registries for these sex offenders. The national portal is critical, but we absolutely believe that we need at least another year and some supplemental change for risk assessment to make this really work, because just like California, most states have spent a lot of time on their registries. What I was trying to say to Mr. Gowdy is we care about the children too. That's why most of us, maybe not as early as 1947, but we've put a lot of time into the whole procedures we have in our sex registries and the way the sheriff's office use them. I would like to say one other thing, if I could. On the money that's been spent by the Justice Department, what they're doing in Kansas, as an example, is we have the national portal software all installed. That's not a problem. That's state to state. But what really matters is county to county, sheriff's office to sheriff's office in the 105 counties of Kansas. To do that, SMART has also created a piece of software called the SORT software, but they have given us a $300,000 grant so that we can tie the technology at each of the sheriff's office together in the state. So when a sex offender changes employment or travels or changes jobs, we can notify. And of course, if he absconds, we can notify. It's that money and the grant money within the state that becomes very important for monitoring as well. I just wanted to put that in because I don't think.
Thank you. I'm about to run out of time. So, and as someone who just came out of the Florida legislature and was involved as co-sponsor of the Jessica Lunsford Act and actually worked with the legislature last year in Florida to come to substantial compliance under the Adam Walsh Act, I am concerned that we're now getting to a level January of this year, we're giving those states that information. And it seems like it's been a very long time coming, and the states are having a hard time complying, but at the end of the day, we need to protect our children. Coming from a state where the capital is about 20 minutes from the state of Georgia, I recognize from law enforcement background that these offenders do travel across state lines.
Gentlewoman's time has expired. Gentlewoman from Texas, Ms. Jackson Lee.
Mr. Chairman, let me thank you for the hearing, and let me thank the ranking member. I remember 2006 when this bill was passed, and Ernie, how hard we worked, and we all know John Waltz, and we know his passion. I just couldn't fathom letting him down and disappointing him, not because he is a person that would override difficulties, but because this is something that has been constructed with not only tiers, but concerted thought processes. So let me begin with the Justice Department, and I just can't fathom why we took so long to get the basic information. As I understand, the regulatory scheme or structure to the states. And if you've already said, please just brief me as to why it took so long.
Are you referring to the supplemental guidelines that were just issued?
That, and yes.
The supplemental guidelines that were just issued in 2011 were really the culmination of a great deal of work from the states, from the jurisdictions, from the SMART office. The SMART office, I would say as early as 2009, did a really comprehensive review of what the barriers were, why states and tribes were having difficulty coming into compliance. And there were obviously a few large barriers. And we met with many of the national organizations, National Criminal Justice Association, National Congress of American Indians, National Conference of State Legislatures, as well as we met with Mr. Walsh himself and the Surviving Parents Coalition. And we really tried to work towards the issues that were causing the most difficulty for the states and the tribes.
And what did you consider were the most difficult ones?
We considered the most difficult ones to be the juvenile issue, the juvenile registration and notification issue, and so within the supplemental guidelines, we did what we could underneath the Attorney General's authority and discretion to allow states the discretion not to post those publicly, those names publicly. Under the retroactivity issue—
And that is if you were a juvenile having perpetrated an act.
That's correct.
All
A
right.
juvenile that would have to register under SORNA.
Right.
Exactly, for a serious sex offense. And then under retroactivity, what we did was we limited the scope that states would have to go back to in order to recapture, and we limited that to felony convictions, as well as those that were already incarcerated or under probation or parole. So we limited that scope for the jurisdictions as well.
And at the time that the law was passed, do you know how quickly before you found the need for resolving some of the most difficult questions, did you have a regulatory scheme after 2006 that got to the states quickly?
The guidelines were issued in July of 2008.
Okay, so it's still 2 years.
That's correct.
And that's a challenge. Let me just ask, if I can, Ernie, if you would, you work through this, you know the horrific circumstances that have occurred. There are some elements that that I will just raise with you on the juvenile question. You know, there's some cultures where a marriage occurs before 18, and there were some issues regarding whether those juveniles, how we actually treat them, if we register them, and they are in fact able to be rehabilitated. I just want you to reflect on that, but more importantly, I want you to reflect upon how important it is to stay the line on this legislation and your sense of the plea by states that it's just too difficult.
Well, first, Congresswoman, on the juvenile provision, we are enthusiastic supporters of the Attorney General's supplemental guidelines. I think it is infinitely reasonable for serious juvenile offenders over the age of 14 to be registered but not be subject to inclusion on the public databases. We believe in the rehabilitative ideal of the juvenile courts, the juvenile justice system, but the reality is the evidence proves, one of the leading researchers talked about the myth of the dirty old man. The typical offender in child molestation cases starts very young.
Okay.
So it's important to identify, to rehabilitate, to direct treatment resources, but we think the Attorney General's accommodation on that is reasonable and is going to enable a lot of states to become compliant.
Let's go to my next two because of timing, yes.
Yeah, the next part is we see real progress. States, I think, largely because of the supplemental guidelines, our sense, as Ms. Duran has indicated, is that states are enacting law, they are moving toward compliance, and we think there's going to be a critical mass in a very short period of time. Now, Representative Colleton's points about timing, I think, have real validity, and that's something the Congress has to grapple with. But we think it's important to stay the course, to implement this, and we think there are going to be a significant number of states compliant in a very short period of time.
Well, I agree.
The gentlewoman's time has expired. The gentlewoman from Florida, Ms. Wasserman Schultz.
Thank you, Mr. Chairman. First, I want to recognize Ed Smart and Mark Lunsford and the other members of the Surviving Parents Coalition that are in the audience, and appreciate their advocacy. My question is for Dawn Doran. I appreciate your testimony on the sex offender registration, and I'm quite proud, along with my colleague, Ms. Adams, that our home state is fully compliant. But as we discuss the reauthorization of the Adam Walsh Act, I want to focus on civil confinement, which is another provision of the law. Now, the representative from Kansas, I'm sure, is familiar with the civil confinement provisions. They have a state statute that went all the way to the Supreme Court and was upheld in 1997 and was really a model law for the rest of the country. There are now 19 states that have civil confinement laws on the books, and because these kinds of crimes are often, more often committed at the state level, that makes sense. But there's also general consensus that most child sex offenders are not, quote unquote, curable, and there really needs to be a priority made in ensuring that following the expiration of a criminal sentence, that there is a way to keep these individuals who are very, very likely to reoffend confined with the proper review that civil confinement statutes require. With Chairman Sensenbrenner's help, I was able to include in the Adam Walsh Act a grant program that provided for incentives for other states to enact civil confinement provisions under certain requirements. And Section 301D of the law required the Attorney General to submit a report to Congress at the end of each year, beginning in 2008, to inform us about the progress that states were making on adopting civil confinement statutes of their own and the rate of sexually violent offenses in that provision. Can you tell me whether that report was ever filed in any year?
My understanding, unfortunately, is that the civil commitment portion of the grant program was never appropriated any funding, and therefore OJP has not issued any grant funding in that area.
Okay, well, let me read to you from the statute, which does not say anything about the report being contingent upon funds being appropriated. It's Section D. It says, Attorney General reports not later than January 31st of each year, beginning with 2008, the Attorney General shall submit to the Committee on the Judiciary of the Senate and the Committee on the Judiciary of the House of Representatives a report on the progress of jurisdictions in this section and the rate of sexually violent offenses for each jurisdiction. There was $87.3 million appropriated for the entire Adam Walsh Act over 3 years. There is nothing in the language that requires that report to be tied to appropriations. Is the Department of Justice in the habit of ignoring Congress's direction?
The civil commitment issue is outside of SORNA and outside the scope of the SMART office, but I will certainly have that information given to you as soon as the hearing is concluded.
Okay, well, I mean, your answer speaks volumes.
Without objection, the information will be included in the record. The gentlewoman may proceed.
Thank you so much, Mr. Chairman. And I can appreciate that in 2008, from the 2007 CR, we had a CR and that there were not substantial appropriations provided for the Adam Walsh Act in general. I was a member of the Appropriations Committee at the time, and to be honest with you, I lament that the Adam Walsh Act was significantly underfunded overall. But the language in the statute clearly says that the Department of Justice was supposed to issue a report. It should have been a priority to issue that report annually since 2008, regardless of whether the appropriations were made. So I look forward to hearing back from you on where you're going to go from here, because I would expect that reports would be generated. Thank you, Mr. Chairman.
Thank you.
The gentlelady yield. Excuse me. The gentlelady.
If I could yield to the gentlelady from Texas.
Thank you very much, and I thank you for your service as well, Congresswoman. Quickly, Mr. Allen, I just wanted to finish your point about your believability in states being able to get this done. I think what you were saying is you expect that there is going to be sort of a synergism of everybody rushing. So therefore, should we not keep the pressure on? There's so many vulnerable children. I'm just trying to hear where you are on this situation.
Congresswoman Jackson Lee, I absolutely believe we need to keep the pressure on and stay the course. I think states have been provided the latitude to come into compliance. I am hopeful that there will be a significant group of states that become compliant quickly. And I think once there's critical mass, there will be significant pressure for the rest of the states to join in.
I agree with you, and I thank
The
you.
time of the
Yield back.
gentlewoman from Florida has expired. I'd like to thank all of the witnesses for giving us some extremely important information as we consider reauthorization of the Adam Walsh Act. Thank my colleagues for their active participation in the hearings. The gentleman from Virginia has a unanimous consent request.
Thank you, Mr. Chairman. I ask unanimous consent that the testimony by Nicole Pittman, a juvenile justice policy analyst attorney for the Defender Association of Philadelphia, be included in the record.
Without objection. And without objection, this hearing is adjourned.